Hello, good morning, and good afternoon for those of you that are in Japan, like myself. This is Lucas Kofian, the project manager of the EU-Japan Technology Transfer Helpdesk. I would like to welcome the speakers of today and the audience. Happy to see known names and new names, which is good. Today it's a very important day in Tokyo for IEP. This morning I was attending the international arbitration mock arbitration in here in Tokyo. Very interesting event with a lot of IP professionals. And this afternoon we have the webinar, so it's a full day for IP from here from Japan. This is technology transfer webinar number 20, and we're going to talk about patents, utility models, overview of requirements, procedures, and tactical use in Europe and Japan with two partners that have worked with us already in the past, with the Murgitroyd from Munich, Munich office, and Sonoda&Kobyashi from Tokyo. And specifically, we have Mr. Shin Akagi, Akagi-san from Tokyo, and Robert Börner from Munich. I would like to give you a little bit of information about the help desk, how to reach me, and then read the bios of the speakers, of course, before giving the floor directly to them. I saw a question prior to the start about the webinar, if it's going to be online. Yes, it will. You will be receiving an email with the link to the publication of the webinar on our YouTube channel, where you can see all the other 19 previous webinars plus other videos. From this slide, you can see my email. So if you want to reach me, please send me an email if you have any questions. The website of the help desk, if you don't know it yet. A link to the survey that we're running for SMEs that is still always open. So if you want to express your opinion, you work for or you manage an SME, please help us improve the service. And of course, last but not least, if you want to hear from us, please do register to the newsletter, which is the last link that you see on the slide. I will at this point start with the bios of our speakers for today, starting with Mr. Shin Akagi, that began his career working for Oracle Corporation Japan, where he contributed to the integration of Java and XML into the Oracle Relational Database Management System by conducting research, implementation, and testing. Later, he developed various B2B products and startup companies in Tokyo before entering the field of IP in 2007. He joined the firm, Sonoda&Kobyashi, in 2011 and heads software innovation prosecution in the firm and advises clients during business trips abroad. As far as Robert, probably many of you already remember him from prior contributions. Dr. Börner studied general physics at the Technical University of Munich, completed his PhD studies at the Université Libre de Bruxelles in Brussels, with the research of chemical reactions on metal surfaces under high vacuum. Dr. Börner is fluent in German, English, and French. In 2001, he started his training as a German and European patent attorney in a mid-sized Munich-based German patent firm, which he completed in 2005 by passing the German and European qualification examinations. He then joined Murgitroyd in 2011 to build up and lead the German office and was appointed Director, Patents and Trademarks in 2013. In addition to his experience in patent prosecution and litigation on various technical fields, Robert also has a wide experience in matters relating to trademarks and regularly travels to Japan to enhance the cooperation with local clients and partners by presenting seminars about European and German patent and trademark practice. Without further ado, I would like to give the floor to the first of our two speakers for today, and welcome to both of you and for being with us today.
Thank you, Luca, for this kind introduction. My name is Robert Börner. I have been introduced already, so without further while waiting, we'll get into the talk now. As we will run through the agenda quite briefly. We'll start with an overview and the characteristics of the utility model systems in Europe and in Japan. Go on to the registration procedure, enforcement, a tactical use of utility models, a cost reduction by tactical use of utility models in Japan, and a summary. I may forewarn you, if time restricts us, we may rather briefly skip point 5, but in any case, you will have it on the slides. And if you've got any questions, you may refer to my colleague Shin from Sonoda&Kobyashi in this context. So let's begin with the first part, a brief overview of and the characteristics of the utility model. In Europe, we don't have a centralized utility model system like the European patent application with the EPO here in Munich. Instead, we have national utility models in various countries. There's Austria, Bulgaria, Czech Republic, Denmark, Estonia, Finland, France, Germany, and all the other countries you can see here. I will briefly talk about the situation in France, Italy, and Spain, because these are maybe the main markets under these countries. And of course, we'll go into more detail in Germany. The table below gives a brief overview of the remaining countries with respect to the lifetime of a utility model, which is different from patents, whether methods or method claims are allowed or not in these countries, because that we will see is one of the peculiarities of utility models, that method claims usually are excluded from protection. We will, in the table, you can see whether with respect to novelty, the same requirements apply as in patents in that countries. There are some exceptions like Austria, Czech Republic, and Hungary. And whether with respect to inventive step, the same measures are taken for patents and utility models. And as you can see, in most countries, the inventive step for a utility model is smaller than for a patent. Substantive examination is also one of the peculiarities. Usually utility models are registered without it. There are some countries where there will be a search carried out automatically. There is even one country, Poland, where you will have substantive examination. In other countries, you will either have the option to request examination or the option to request a search, or there will be no substantive examination at all. So let's come to Italy. In Italy, lifetime of a utility model is 10 years, and it's no method claims allowed, just apparatus claims. They have an absolute novelty requirement, so there is no grace period, there is no, exceptions from prior art. And the inventive step is less than the inventiveness for patents. So it may be possible to get a utility model if a patent wouldn't be possible due to a lack of inventiveness. It's an only formal examination, but it takes up to 2 years, which is rather slow for a utility model. If you start litigation, then the validity of a utility model will be reviewed during the litigation. Interestingly, a conversion to a patent is possible, and it's the most important point in my view. If you have an EP patent application and it's rejected, revoked, or withdrawn, you may still convert it into an Italian utility model. Additionally, there's double filing as patent and utility models possible, but one drawback in Italy, which may be changed, is that there's no PCT route directly into Italy. So if you want to file a utility model, you need to take it from the Paris route in the first priority year. As you will see, I will rather briefly skip through these 3 countries. If you've got any questions, just let us know, because Murgitroyd is situated in these countries, and if not myself, my colleagues are happy to help you with any questions you've got in these countries. In France, we have a certificate of utility, which is not very different from a patent. It's got the same subject matter. The main difference is you've got a lifetime which is limited to 6 years. You also have an absolute novelty requirement. The inventive step is the same as for patents. Only formal examination, as with patents in France as well. You get a grant within 2 years, again, quite late, and you have the possibility to request earlier publication. Interestingly, if you want to start litigation in France, you need to have a search report. And the problem is you cannot amend the claims in reply to the search report. A conversion to a patent is not possible. It's not possible to have a certificate of utility in coexistence with a standard patent in France. And again, we have the PCT route closed in France. Which brings us to the next. It's a utility model in Spain. Again, lifetime is 10 years, and it's no methods allowable. It's just apparatus and composition claims. Up until 2017, it was quite interesting because only national novelty requirements have been present in Spain, but that was changed. So we also have now an absolute novelty requirement worldwide disclosure in Spain. Again, we have inventive step, which is less than the inventiveness for patents, and we have only formal examination. And the grant is within 5 months, which is already faster than in the other two countries, but still quite long if compared to Germany, as we will see later. One of the peculiarities in Spain is that any third party may file an opposition after the publication of the utility model, and in this opposition, the validity will be reviewed. Again, as in France, a search report is obligatory for litigation, and the PCT route is possible for Spain, so you can come from a PCT application to file a utility model in Spain. So that's the overview of the first 3 countries. Briefly coming to Germany, we will discuss all these details later. In Germany, it's quite interesting because we have more than 13,000 utility models which had been filed in 2017. There have been, in the same time, 67,000 patents. So it's roughly 20% of the patent filing. So utility models in Germany are quite an important IP right. From these applications, 71% came from Germany. Alas, there is no possibility to see where the other 29% come divided by countries. With respect to a patent, in Germany, utility models have a grace period. So every disclosure which has been made by the applicant within 6 months before the filing of the utility model will be blanked out and will be not prior art. There is no substantive examination which leads to a real fast registration. Up to some days, we will see that later as well. With respect to the novelty of the prior art, one peculiarity also in Germany is its written description will be counted worldwide. However, if there has been a prior use of the invention, it will only be relevant as prior art if that prior use has been taken place in Germany. With respect to the subject matter, again, methods, biotechnical inventions, and non-technical matters are excluded. However, quite interestingly, a second medical use claim is allowable for a utility model in Germany. Lifetime is 10 years, and also very interesting, you can have a double protection with a patent. So you can have identical claims in a utility model and a patent. However, you cannot convert a patent into a utility model or a utility model into a patent. But we will see later that there's an interesting option called branching off a utility model for a patent application. With respect to the costs, very cheap. You have 40 euros official fees for filing a utility model, and that includes all the costs up to registration. So, Shin, how is the situation in Japan?
Hey, thank you. Thank you very much, Mr. Robert. My name is Shin Akagi, and I will talk about Japanese utility models perspective now. Let's first look at the most important characteristics summarized on this slide. Last year, there was a total of 6,105 utility models filed in Japan. This is a small reduction compared to 2016, where we had 6,480 applications. The majority of applications, 75% to be exact, was filed by Japanese entities. After Japan, Taiwan is the biggest applicant with 854 applications, followed by China. Since this June, the grace period for utility model is 1 year, which is the same as for the patents. One of the big differences compared to patent application is that there is no substantive examination in utility model prosecution. This is the reason why one can get protection very quickly. Novelty is considered worldwide, just as with patents. Protectable subject matter is the shape, the structure, or a combination of these. Methods, on the other hand, cannot be protected by utility models and are subject to patent protection. The lifespan of a utility model is 10 years in Japan, too. Contrary to other jurisdictions, multiple protection by the use of utility model is not possible in Japan because the exact same claims are not allowed. In Japan, a utility model can be converted to a patent if certain criteria apply. The conversion must take place within 3 years from filing the utility model application. After the registration of the utility model, it can only be converted if the technical evaluation report has not been requested. I will explain later in this presentation what the technical evaluation report is. One of the big benefits of the utility model compared to the patent is the low cost. Since there is no substantial examination, the official examination fee fall away, and also the cost for office action is reduced to a minimum. The total cost from filing to grant for utility model is therefore only about 300,000 Japanese yen or 2,500 euros. Now back to Robert.
So thank you, Shin, for that update on. Yes, I'm here. Sorry, I muted my phone, my mic. I'm back again. Sorry. Thanks for that update, Japan. We will come back to the registration procedure and a comparison between Europe, or at least Germany, and Japan in this context. As I said before, in Germany, the registration of a utility model is very fast and very cheap. You have registrations within days, as you only have a formal examination. So we had cases where we filed the utility model on a Friday, and on the next week, Wednesday, we received the information that it has been registered already. If you don't want your utility model to be registered that fast, there is a request possible to postponement of registration up to 15 months after the priority date. As we all know, there may be situations where you don't want it to have been registered so fast. Additionally, quite interestingly, there is no claims fees for your utility model, so you can file as many claims as you want, in difference to a German patent where you have to file quite reasonable claim fees. You have to pay them in any claim in excess of 10 claims in Germany. One of the most important things is, we will discuss it later with strategic points as well, you can have double protection possible, which means you can have a patent and a utility model at the same time for the same claims. You can even have one or more utility models referring to the same invention. These, of course, should have not identical claims, but in principle it would be possible. One of the most important strategic options for utility model protection in Germany is the branching off from a patent application, which we will discuss later in detail. But I think, yeah, the details will follow later. It wouldn't make any sense to discuss it now. You can file a utility model, register it in Germany from a PCT application if Germany is designated. You have to file a German translation for your utility model, which can be filed up to 3 months after filing of the utility model, which is quite interestingly because, you know, the PCT in Germany, you have only 30 months, and you have to file, usually, if you file a patent application, a translation upon filing. So if you don't have the translation at hand, you can opt for a utility model and then file the translation within 3 months. Okay, so heading back to Shin with the next foil, how's the situation in Japan?
The next step, the PCT application filing original language is the basis of the examination. A Japanese translation must be filed within 2 months from the entry into Japan. On the other hand, Paris route application must be filed in Japanese. Since the translation of the full document takes time, it is important to send a utility model application early to your Japanese counsel. Voluntary amendments can be made after filing until the utility model is registered. During the formality examination, it is checked whether the claim subject matter is configuration, a structure, or combination of an article. Whether the subject matter conforms to the public order modality, and whether the application meets the formality requirements such as name of applicant. After necessary formality amendments are made, the utility model already gets registered. This normally happens within 6 months from filing. As for registration fees, contrary to the patent application, the first 3 years of annuity fees must be paid at the time of filing in addition to the filing fee. At a later stage, if an annuity is missed, it is still possible to pay within 6 months from the missed deadline. Okay, now back to Robert, please.
Thank you, Shin. Luckily, we got over these technical problems. Let's come to the next point. It's enforcement. In Germany, a utility model will have to be enforced at the patent chamber of the civil courts, as it is the case with patents. And also the legal consequences as known from patent law will apply. So you can request an injunctive relief, you can request damages and the like. And quite interestingly, in difference to a patent in Germany, the validity can be assessed upon request during the infringement proceedings. So you have the civil court discussing whether the utility model is new and inventive. This is completely different from patents, and it may lead to some problems because you don't know about the technical knowledge of the judges. And in some cases, they will call in for expert opinions. And well, it's a question whether that's an advantage or disadvantage, but I think it's a peculiarity. And in reply to a request to assess the validity, it's quite interestingly, you can change the claims of a utility model during the dispute, and that will have only an effect inter partes between the parties in the infringement proceedings. A utility model, even if not having been examined, may be the basis for a preliminary injunction. However, according to the case law here in Germany, the validity has to be somehow confirmed. That's usually if you have a parallel patent which had been examined substantively or even survived an opposition proceedings. In a dispute, every utility model may constitute individual matter. So if you have several utility models and you file infringement actions against someone, each of these cases will constitute individual matter. And you can also assess patent rights and utility model rights at the same time. So you have a double strategy to attack someone for an infringement. With respect to liability issues, it is very highly advisable to have carried out at least a search before starting litigation. That may be an official search. You can request a search from the German Patent Office. You can request a search from another patent office. You can have a private company search the utility model. But the problem is if you start litigation with an utility model which hasn't been examined or for which no search has been carried out, you may have to pay damages to the other party if it turns out that the utility model was not valid from the beginning. If someone receives an infringement action based on a utility model, the standard defense would be an invalidity action at the patent court. In this case, we will have two proceedings. You will have maybe the infringement action going on. At the same time, you will have an invalidity action at the patent court. The infringement action may be stayed until the decision in the invalidity action has been rendered, but that's not a must. So you may end up with two pending actions at the same time in this case. So how's the situation in Japan when you try to enforce your utility model, Shin?
Okay. In Japan, if we're company wants to use the utility model for enforcement against an alleged infringer, one must be careful to follow the necessary steps. First of all, it is compulsory to request a technical evaluation report, which is issued by the Japan Patent Office. Without a technical evaluation report, a utility model cannot be used for enforcement. The cost for a technical evaluation report depends on the number of claims, but in our experience, ranges in between 100,000 to 200,000 Japanese yen. That is 800 to 1,500 euros. For a utility model to be valid, novelty, inventive steps, and disclosure requirements must be clear the same way as for patents. These requirements, however, will not be examined when registering a utility model. Only if a technical evaluation report is requested will these requirements be examined substantively. After a utility model is registered, it can be corrected only one time. Although the deletion of claims, the narrowing of the scope of the claims, or the correction or clarification of errors. Shifting or broadening of the scope is not accepted. Since one has only one shot to amend the claims, we recommend to check what happened in other jurisdictions and amend in the same way. When enforcing a utility model right, one should be careful because the utility model right owner can be held liable for damages if a utility model is subsequently invalidated, unless the enforcement is done with a positive technical evaluation report. Therefore, right holders should enforce a utility model right only if they have received a positive technical report. On the next slide, I would like to show the order of actions a company should take when enforcing a utility model right. If a right holder discovers infringement after the registration of their utility model, the right holder must first request a technical evaluation report from the JPO. The JPO will then provide their opinion on patentability in regard to novelty, inventive step, unity, and enablement. If the technical evaluation report is positive and the utility model deemed to be patentable, then a right holder can send a warning letter together with the technical report to the alleged infringer. If the technical report is negative, however, we recommend not to use the utility model to enforce the right. The utility model right holder can amend claims in response to a negative technical evaluation report within 2 months, and the requested technical evaluation report for the second time to receive a positive report. With the positive technical evaluation report, a utility model can be enforced the same way as a patent. If the judges at the responsive district court rule on infringement, the defendant will be liable for damage compensation and the return of undue enrichment. Furthermore, in nearly all cases, injunction will be ordered. So it is important for utility model right owner to remember that they will be kept responsible if they warn an alleged infringer by using a utility model which is subsequently deemed invalid. Damages in such a case can be quite painful. Right owner can only be exempt from liability when they had based their warning on a positive technical evaluation report from the JPO or enforced with due care. Okay, now back to Robert, please.
Thank you, Shin, for that interesting evaluation of the infringement and enforcement in Japan. Let's come to the tactical use of utility models. And now finally we come to this famous branching off. What is branching off? If you file a utility model, you can file a request that it is a branched off from a pending patent application. The effect is that the utility model will receive the effective filing date of that patent application. That is quite interestingly because you can file it at any time of the pendency of the parent application. The requirements for filing for branching of a utility model is that you have a pending patent application designating Germany. This may be a national German patent application, a European patent application, or even a pending PCT application in which Germany has been designated. Interesting, the deadline for branching of a utility model is quite complicated, within 2 months from the end of the month in which processing of the patent application or any opposition procedure is terminated. So even if your patent at the EPO has been rejected, you still have 2 months time at least to branch off a utility model, which will then have the exact filing date as your European patent application. Even more interestingly, let's imagine that you have your patent granted 6 months later, your European patent, 6 months later someone files an opposition, and during your opposition new prior art shows up, or you've got a formal problem with the EPO. During the opposition you still can file a branched off utility model in Germany. Of course, the branching off requires that it's the same invention, the same applicant, and in view of the shorter lifetime of a utility model, it's only possible until 10 years after filing of the parent application. The advantages of such a branching off is you've got a real fast protection, for example, against infringement activities during the grant proceedings in Germany. You have to imagine, once you've got your European patent allowed by the receipt of the 71.3 communication, you still have to file for the claims translations, and the EPO will then have to take some time for the publication process to be carried out. And as we learned earlier, you have only several days until your utility model is registered. So if you have an allowed EP patent and you have an infringer in Germany and you need to act fast, you can file a utility model, branch it off from the European patent, which is allowable. So you have already an examined claim set for your utility model, and then you can start directly infringement actions. Additionally, for the claim wording of a utility model, you can adapt these to better match the infringing embodiment. As we said, an infringement action will be brought to the standard courts. And of course, having a judge with no technological background, it's always better if he can really compare the embodiment which is infringing with the claim, and he sees, well, it's directly directed at these and these features. So if you've got your claims within the allowable scope, to amend them to better suit the embodiment, if you have, of course, disclosed that originally, then that's an option to adapt the wording. And even one of the advantages, imagine that you have a patent application and suddenly you have a prior use which have been taken place in the US, which may be considered for your patents, but not for your utility model. So you can branch off your utility model from a patent if prior art turns up, which can be a problem. Of course, also with the EPO, we know you can file always divisional applications. They're quite costly. And if your main interest is within Germany, you should consider just branching off a utility model from your European patent application. And as I mentioned before, it's possible after grant of the patent during opposition. You still got the 2-month time limit. So let's just have a better look at this strategy on a slide here. So usually, if we have a patent application, you file it, you file the PCT application, and then, oops, sorry, I'm trying to move the arrow. Let's stop that. So you have the PCT application and you have your scope of claim. The red dot is the infringing embodiment, which falls into the scope of your claims. You've got the publication of the PCT after 18 months, and you've got some provisional protection from that point on. Then after 31 months, you usually enter the regional phase in Germany. You can enter it earlier if you want to, but then still you have to follow the examination procedure, and in the end you have a grant with a slightly reduced scope of the claims. Hopefully the infringing embodiment is still part of that. And then you have your grant of a patent and you've got full protection. So what's the advantage of a utility model here? if you compare the time frame here, you can see even before publication of your utility model, you could branch off a German of your PCT application. Sorry, even before the publication of your PCT application, you can branch off a German utility model, and you can even adapt the scope of protection. I try to visualize that by the smaller ellipse still circling around the red infringing ellipse. And you can have that registered. You can have a second one with a different scope of protection, still claiming the infringed embodiment. You can have that branched off. You can have that registered. And you have the full protection within days after the registration. So from the strategic point of view, branching off of a utility model is a very mighty tool within Germany if a 10-year time frame is still allowable, and if you're not claiming any method claims. So how's the situation in Japan again, Shin? Oops.
In Japan, utility models are used less than patents. And we can think of two reasons. The first reason is the inventive step requirement. Unlike China, where inventive step requirements are less strict for the utility models, the same inventive step as with patent is required for utility models. Therefore, there is no incentive to file a utility model application for small, less inventive inventions. This is contrary to the time when utility models were introduced to the Japanese intellectual property law. Back then, utility models were meant to provide protection for minor inventions. The second reason is due to the condition of the technical evaluation report. A technical evaluation report is compulsory in enforcement, and enforcing a utility model right with a negative technical evaluation report can be penalized by damage compensation if the utility model is later invalidated. However, the opportunity to exchange opinions with the examiner and to amend the claim is not provided by the law, but normally one gets only one shot. In view of patent prosecution procedure, where patents are granted only after filing amendments and remarks, a technical evaluation report made without exchange of opinions and an amendments will be very often negative. Although utility model application might not be recommendable for all inventions, there are some cases where they are superior to patents or other ways of protection. The first situation is when time is needed to determine whether the technology is really important. By filing a utility model application, the decision whether to really pursue a patent can be delayed up to 3 years. If the invention turns out to be important within the 3-year period, the application can be converted to patent application and examination may be requested. If the invention turns out to be less important, then the utility model may be maintained. And in contrast, if a patent application is filed from beginning, there is a choice whether to request examination or not within 3 years. If requesting examination is decided, the result is the same as the utility model converted to a patent application. However, if the decision is not to request examination, the patent application is abandoned and no right remains. The second situation is for defensive purposes. If the possibility to enforce the right is quite small, utility model applications are more cost-effective because the substantive part of the cost for obtaining a patent is spent for examination, which does not exist for utility models. If, however, the necessity to enforce the right arises, this is still possible. The third situation is when company needs prompt protection. When prompt protection is needed, utility model application must be filed with patent application. Standards of double patent is very narrow, but they are not applied if the claims are not identical between the utility model and the patent. So on this slide, I would like to show how a utility model application can be used to gain time to make business decision on whether invention is important or not. If a company files a utility model application, they can wait 3 years to decide whether the invention is relevant for their business or not. If the invention has become relevant, the application can be converted into a patent application and the examination can be requested. If the invention is not considered to have high importance after 3 years, the utility model rights can still be kept for the remaining 7 years and used for enforcement in case of infringement. If a patent application, however, does not show any business relevance after 3 years and the request for examination is not filed, then patent application is deemed abandoned. In this case, the cost for filing a patent invention is lost and the competitor cannot be prevented from selling the same invention at a later stage. And next two slides show an example how you can reduce costs by including utility models to your IP portfolio. And since the slides are self-explanatory and we are running out of time, I will skip the slides at this moment, and you may stop the presentation and upload the video to study the slides if you wish to learn more about the topic. And with that, we are already coming to the summary. Back to Robert.
Thank you, Shin. And I think you're right. We're running out of time. We don't want to stay too long online. A brief summary about utility models in Germany, the advantages and the disadvantages. In my view, one of the main advantages is the branching off option to make use of a pending patent application to branch off a utility model. The grace period of 6 months is also an advantage if you happen to have shown your invention before filing, which we all know you should never do. We have a different definition of the prior art. No prior use outside Germany is relevant. We've got the extremely fast registration procedure. We've got the possibility of double protection between patents and utility models, or even several utility models covering similar or the same invention. And what's also another advantage, which I haven't mentioned so far, if you've got your utility model registered, then it's published. However, you can file an amended claim set, but that will never be published. So it's like having a submarine claim set at the registry of the patent office. And when you file an amended claim set, which of course may be possible due to prior art, which you learned about, then this claim set will replace the published claim set. And by filing this amended limited claim set, you undertake only to litigate your utility model in the scope of these amended claims. This is a very funny situation because to the outside world, your utility model will still claim the broad scope of protection, while in fact you already limited yourself to a rather narrow scope. So if someone assesses a utility model rights against you, the first step should be to have a close look at the file at the German Patent and Trademark Office by filing a request for file inspection. And it is very, very cheap. The disadvantages, well, you've only got a lifetime of 10 years, but if you compare that, the average lifetime of a patent is 11 years plus minus. Many people just don't pay annuities anymore after 11 years. And I think with the fast developing technologies, this makes sense. Another drawback is the exclusion of method claims, of course. And additionally, if you aim for preliminary injunctions, a utility model only without the validity having been examined in parallel patent prosecution or opposition proceedings is also a drawback. And never forget that if you bring up an infringement action to someone, the validity of the utility model may be reviewed by the infringement court. One final word, because I think I haven't mentioned it before, inventiveness in Germany refers to the patents, whereas in the utility law, model law, people speak about an inventive step. And up to some years ago, there was really a difference between the level of inventiveness between utility models and patents. However, the jurisdiction of the Federal German Patent Court, Federal High Court here in Germany even, they clearly stated that there is no difference between inventiveness and inventive step. So the level is the same. And with this, I hand back to Shin for his final summary.
In Japan, advantages for utility models, the prompt registration, the low cost, and opportunity to change the utility model into a patent application if an invention turns out to be important for business. And also disadvantages are the short lifespan, the exclusion of method claims, limited option to enforce one's right, the responsibility of an owner in case of invalidation of a utility model, and a limited opportunity to amend the claims. Yeah, I hope we could provide you with a good overview and understanding of the different systems. I would like to thank you very much for your time, and please feel free to contact him, Robert and me, should you have further questions. Thank you.
The same applies to me. Thank you very much for your time taken on a Friday morning or afternoon to join us for this webinar. And as far as I understand, we may have some questions, and we've got some times for a Q&A session, and I hand over to Luca for that.
Thank you, Robert. Thank you, Shin-san, also on my behalf, of the Helpdesk behalf, and also I would like to thank you on behalf of the audience. I'm sure that everybody really appreciated, as I did, the very, very thorough explanation. Now we can say that we know pretty much everything about utility models, which is really good. And once again, I would like to say, to remind the audience that for those that were not at the beginning with us, we will publish, as usual, the recording of the webinar and also the presentation. So you will be always able to take a look and study at a later time if you want to take another look or listen again to the webinar if you didn't have the chance to be with us for the entire time. That said, I can see that there was originally a question during the first probably 15 minutes, a question for Robert about the grace period in Italy, France, and Spain, I guess.
Yes, thank you for that question, Peter. As far as I know, and I just checked it during the webinar, there is no grace period in Italy, France, and Spain. So utility models have the same novelty requirements as the patents there. And I think in the grace period is something unique in Germany, and I think it's in Austria we've got something similar because they have a quite similar utility model system. And yes, but there is no grace period, according to my understanding, in France, Italy, and Spain. I hope that answers the question.
Good. I don't know. I will leave probably a minute to the audience, those who are still here with us, to maybe formulate a couple of questions. I do have one for both of you. Sometimes I receive questions, especially from startups, maybe involved in the IT field, and they're asking me if in some occasions, some instances, they can resort to utility models rather than patents for registering software. So I would like to know if you have an answer for that from the EU, German side, and Japanese side.
Well, I think the problem with software is always that, in fact, it's relating to methods and algorithms. So as we said, in Germany, method claims are excluded from registration as a utility model. And it will also be examined whether it's a technical solution, and technicity is a problem there as well. So according to my understanding, software is not possible to be protected by utility models in Germany. I assume that that will be the same case for all the countries where method claims are not allowable.
Okay, in Japan, it's situation is the same as probably Europe, because the software invention always has method claims, so it's difficult, often difficult to file utility models. And also, for software inventions, it often to happen that the invention is too complicated for just register a utility model. It's need probably we want to communicate with the examiner like several times for amending claims. So probably it's better to get file a patent better than utility model in terms of software inventions.
Perfect. Thank you. This helps a lot, and I'm sure that those that are interested in the topic will find these answers pretty useful. In the meantime, I don't see any questions yet, so I would take probably advantage of this to say to the audience that this is the last webinar prior to the summer. And the next webinar will be aired at the end of September, and then we will go on until the end of the year with October, November, and December. So please stay tuned. In the meantime, we also published, and we're still publishing new podcasts on our channel dedicated to podcasts. So I invite you to take a look and listen to the podcasts. And please, again, do send us an email. Here on the last slide, you see the email for Akagi-san and for Robert. So please, and of course, at the beginning, you saw my email. So please do be in touch and let us know if you're happy about the webinars. If you have any questions, we'll be more than happy to answer and get back to you. I would like once again to thank today's speaker for being with us, Eva from Brussels as usual, to help us out, to make everything perfect, and of course the audience, all of you today that have been with us, and I'll see you in September.
Thank you.
Thank you. Bye.
Thank you very much. Thank you.